Grant.
Thank you, my lady. I've discussed matters with my learned friend, and we propose, subject to the court, that I carry on until the latest 3:15, if that's convenient to the court.
You're content with that?
Yes, my lady. I don't think I'm going to be very long, so I think my learned friend can really have as long as he wants, as long as he gives me my, let's say, 30, 40 minutes.
Thank you. Well, let's say 3:15.
Thank you, my lady. Now, I was, when the court rose, we were on the 9th of April 2020, which was the day that Mr. Sue was released from his first stint in Pentonville, albeit subject. That was the success of 2 orders, of course, which were all aggregated together because he was committed a second time while he was still serving his first sentence. So the 2 sentences blended seamlessly into one. He leaves on the 9th of April, and my lord, my lady, I think that might be the proper moment for us to go to Mr. Sue's witness evidence, which is at tab
10.
Tab 10. Thank you. I'm so sorry. Tab 10. Now, it's fair to say this evidence dates to the 14th of December, and it was served in support of the application that was made at around that time. We have the application notice, which I think is actually dated the 7th of December, and it was the evidence that was before Mr. Justice Waksman on the second occasion. And that was the occasion, of course, where he made the order, which is subject to appeal today. Nonetheless, although it's dated the 14th of December, it does set out evidence about his life, so to speak, in during the operative period, i.e. from the 9th of April. If we can pick it up at page 66. Which is the day of release, paragraph 20. Now, I don't want to be seen to be gliding over or glossing over any prior dates, but the court has his own version of events, for what it's worth, up until the 9th of April in the 2 pages immediately preceding page 66. He is released, he goes to live with a friend, and was reporting to a police station. He then, on the 11 days later, he moves in with a friend called Mr. Robert McKendrick, and he then started reporting to Charing Cross. Now, Mr. McKendrick is the gentleman who my learned friend made reference to as a cellmate of a former cellmate of Mr. Sue, and it's a public fact, and my learned friend rightly made reference to it, that Mr. McKendrick himself has appeared before this court in recent times and made a little law in a case called FSA and McKendrick, which is one of the leading decisions on sentencing in committal cases. Mr. McKendrick himself was a contender, I should say. And that's why Mr. Sue came in contact with him, because they both found themselves subject to contempt, to committals at roughly the same time. And Mr. Sue then deals with various other events, which I'll come back to. If we can just turn over the page to page 68, or page 67, perhaps. My lady raised the bankruptcy question, and he deals with that at paragraph 34, page 67. He applied for bankruptcy on the 4th of July to bring the never-ending nightmare to an end. Didn't do much good, but anyway. Of course, I'm in no position to make any submissions about the underlying debt. He was declared formally bankrupt, this is paragraph 35, on the 7th of July. And he talks about how that's contested. And indeed, we'll come on to the hearing before Mrs. Justice Bacon, which occurred only very recently. He then talks about his private and family life from paragraphs 37 onwards. And it's important we look at this with some care, in my respectful submission, because it engages 2 issues. 1, the proportionality question under Article 8, and 2, the question of, which may be a similar question, I accept, the imposition of the passport order as a matter of common law upon this gentleman. I've not been able to spend time with my friends outside of England and Wales, and have only been able to communicate with them by electronic means throughout the pandemic, which was a particularly lonely time. Friends I have in the UK have mainly been people who have helped me and assisted me through these tough times. I've not been able to meet with friends in Japan and enjoy even a limited amount of the social life I had prior to coming to the UK. I don't think anyone suggests that this gentleman was in any way connected to the UK before his arrival on the 10th of January. Or I don't think anyone suggests that he arrived on the 10th of January 2019 in the UK, not to engage in a protracted tour of the country, but simply in transit to Germany. He then says that he's an avid tennis fan, reaching retirement. I should say, I believe he's 62 or 63 years old. I simply wish to head back to Japan and enjoy what I have with my friends and enjoy small pleasures such as being able to play tennis and teach others how to play. Family life. My mother is the respondent, as the respondent is aware, is very elderly and frail. I've not had physical contact with her in some time. Whilst our relationship is not always great, we still love each other very much as a mother must of her son, no matter what stress we cause them. I wish to see my mother and celebrate events with my family as we formerly did. Can I just interpose there? The court may have seen mention of the fact that there has been a fresh set of proceedings brought in recent times by Lakatamia, in which my learned friends have been instructed, as indeed have their solicitors, against Mrs. Sue, or Mrs. Morimoto, I think she's referred to perhaps, and that those proceedings were issued on the back of certain comments that Mr. Sue, I think, made at his first means hearing in March 2009, or February 2019, and related to some large sum of money which had been transferred to Mrs. Sue. Again, I can't assist the court. I've not read the judgment, which came out, I think, a week ago or so, of Mr. Justice Breyer. I believe it's a very lengthy judgment in which judgment is given for Lakatamia against Mrs. Sue, the mother. I believe it is common ground and mentioned perhaps in the judgment itself that Mrs. Sue is resident in Japan and is 87 years old or thereabouts. If I've got that wrong, my learned friend will correct me, but I believe that's the case. 41. My children have also not seen me. I do not wish them to come to the UK, as there's always a risk that the respondent will try and do something to put pressure on them to give up money they think I have. I cannot give them things I do not have, but they're determined to put whatever pressure they can on me. I very much wish to return to Japan, spend what time I have left with my mother and children. Life in the UK. I note that the best evidence of my conditions of living comes from Mr. Gardner, and what he says about my squalid little flat. Pausing there, my lady, the phrase squalid little flat actually emerges from the mouth of Mr. Gardner. And essentially what I understand happened, or the circumstances in which this phrase was used, this rather poignant or vivid phrase is used, is that, as the court may have seen, a little later in the chronology, in June of 2020, the applicant, the respondent, Lakatamia, applied for a search order of the flat where Mr. Sue was then resident, and indeed I think remained resident until last week, when he became resident elsewhere. And that search order was granted by Mr. Justice Andrew Baker, again in the commercial court. It was executed the day after, I believe the 8th of June, or sometime in June at least, or the 18th of June perhaps, and yielded a vast cache of documents. Apparently I know nothing about them, but I'm told they are. The evidence is that 800,000 documents were revealed by the search order, which was executed, I presume, against computers. And Mr. Gardner, in a witness statement, which I'm afraid the court doesn't have, but maybe mercifully pleased not to have, but in the witness statement that Mr. Gardner made, or an affidavit, after the execution of that search order, Mr. Gardner gave a very vivid account of what he confronted when he came along with the search party on the 18th of June, I think it was, 2020. He finds Mr. Sue in what he was describing, what Mr. Gardner, this is not Mr. Sue trying to sort of do down his lodgings, this is Mr. Gardner's phrase, a squalid little flat. Mr. Gardner paints a very vivid portrait in that witness statement of basically a flat without any furniture in it to speak of.
I mean, I'm sorry, may not matter, but is this a flat that belongs to Mr. McKendrick?
Yes, I believe so. I believe so.
But what does your client do? He rents it from him, or
I think he just lives there as a on a gratis basis. That's my understanding. Obviously, I don't know. I've never spoken to Mr. McKendrick. I haven't spoken to Mr. Sue about this. But I understand he lives there.
But he doesn't have a tenancy of that flat.
No. But I may be giving evidence here, but my understanding is maybe there's evidence.
I'm just trying to understand what his evidence is.
My lord, I obviously am constrained by what I've seen and what the evidence is, but there's been a lot of evidence put into this case at various stages, as your lordship will no doubt be aware, will appreciate. But my understanding is that that it's common ground that Mr. McKendrick owns the flat. He has lent it to Mr. Sue as his former comrade in arms in Pentonville, so to speak. That Mr. McKendrick, that the flat is not subject to any tenancy agreement between the two of them, and as I understand it, the flat is subject. Essentially, it's mortgaged. Mr. McKendrick did not pay the mortgage instalments. They are subject to a possession order, and the only reason the possession order hasn't been executed is because of the COVID rules to Part 55, which have, as I think is well known to the court, have prevented residential premises from being the subject of possession, actual physical possession.
Yes.
So Mr. McKendrick and in turn Mr. Sue have been the beneficiaries, albeit indirectly, of the government's COVID response in this particular regard. Back to Mr. Gardner's evidence, which I have read, although it's not before the court, I think Mr. Gardner says essentially he was there in this sort of...
He wasn't there.
Okay, he wasn't there, but he was...
It doesn't matter, actually, Mr. Grant. We have the phrase "squalid little flat," and you say that comes from Mr. Gardner's description. And I think that will do, won't it?
But I should say against myself, or potentially just because I don't want to be seen to be trying to be... I think Mr. Gardner would say, or might have said in the past, that this was a sort of set-up to sort of make it look miserable.
And that's what Mr. Sue says, but that's not the case, he says. And here, he says, I live here to show I don't have any money, but I've never mentioned the conditions of my flat prior to him using the information he obtained from the search order.
I think the point is that he didn't know that Mr. Gardner was going to turn up on the 18th of June. Anyway, that I don't want to spend too much time on that, but as my lady rightly points out.
But I mean, if he loses possession of the flat through the mortgagees or for any other reason, I mean, the passport order, if it continues, will have to specify place of residence for him. And I mean, it can't operate unless he has a specific place of... I mean, if he's just, so to speak, street homeless, I mean, he obviously can't operate on that basis. So I imagine that if he's not able of his own means to put a roof over his head, the claimants will have to do it as a term of the passport order.
My lord, I don't know.
No, well, I don't either, but I mean...
on my understanding is that now that he's no longer there, I presume that there should be no bar to the mortgagee executing its possession order, and I suspect the COVID rules are, I think, imminently to be lifted in any event. So that would be paid to this flat in Maida Vale.
Anyway, he's been living in this flat while he's been out of prison.
Mr. McKendrick was in the buy-to-let business, wasn't he? I'm reminding myself of the judge.
My lady is ahead of me, I'm afraid.
Right.
It might be right. It may be something said about that in the judgment of the Court of Appeal in 2019. I have read the judgment, not recently for this purpose. My lady may well be right. So we can then read, your ladyships and my lord probably have read on to the end of page 69, and one sees the consequences. And then para 48, can't register the GP. Para 47, no right to use the NHS. Para 49, technically not allowed to obtain my own tenancy. That is right, as I understand it, under section 33B, I think it is, of the Immigration Act. It's a criminal offence for a person to rent a flat to an overstayer. Can I just say, lest this be thought to be evidence that is somehow party pre or that the court has Mrs Justice Bacon's judgment, which was delivered 2 weeks ago on the appeal against the bankruptcy order. And that is at tab 8 of my learned friend's supplemental bundle. It's the third bundle. I don't think we've actually looked at it yet. But it's tab 8, and perhaps I can just invite the court to look at paragraph 12 of that judgment of Mrs Justice Bacon.
Well, you're going to have to
Can I could read it out if it's an
identify
assistance.
which bundle we're talking about.
Yeah, it's the third bundle
Is
of
this
authority.
Respondent's supplementary authority?
I suspect that's exactly it, yes. My
Yes, it is.
It's tab 8, para 12. Where it's recorded by Her Ladyship that, this is the point I made before the short adjournment, as a Taiwanese Japanese national, he was permitted to remain for up to 90 days without a visa. That period has long since expired. Common ground that he has no right to remain in the country, nor does he have any right to rent a property or work in the UK or to access the NHS. That's no more than what he says in his witness evidence, but it may come rather more forcefully from Mrs Justice Bacon as common ground. So, and then if we can just go over the page, please. Page 70 of, I'm so sorry, page 70 of the core bundle rather than the judgment of Mrs Justice Bacon, which your court can put aside. Para 50, I don't know what I'll then do after he's evicted from the property, that is. I suspect I'll have to ask the claimant to rent. This is my Lord's point. My Lord is ahead of the game. He says, ask the claimant rent me a property until such time as the means hearing is completed. Now, of course, to some extent that's been overtaken by events because he's now being accommodated by the state in a manner of speaking. My time but he will come out at some point, and either in 12 months' time or if an appeal is successful in less than 12 months' time. My time in prison was horrific, and the court can read on. Don't think I need to read out till the end of para 54. Court can read that if it would. And then finally, 55. I very much wish to return to Japan and have some semblance of a life. I still feel I can win the case overall and show the debt was not incurred. I can't comment on that. I can't assist the court on that. That's all I wanted to show the court in respect of these paragraphs of Mr. Sue's witness evidence, and the court can put that to one side now if that's convenient. Now, I think it's important for the court to understand what then happened after the 9th of April. Your Lord, the court has been given at least Mr. Sue's version of his life thereafter. I don't wish to lay it on with a trowel, but a half-life, really, without ability to do anything productive. Now, of course, I understand the point that will be made against me, which is that Mr. Sue is the author of his own misfortunes. If he is living such a miserable, unproductive life, then he must look to himself. Those are the facts, though, as a matter of reality. As I've explained, there were, I should say, because my learned friends refer to it in their supplemental bundle, their supplemental skeleton argument, there were some decisions of Mr. Justice Foxton, which are relatively lengthy judgments in April, just before he was released from prison, which deal with a whole panoply of matters, and indeed one of them has been reported in the weekly law reports. One of the points my learned friends make is that there Mr. Justice Foxton, without demur, extended or continued the passport order or what have you. I'm not aware that Mr. Justice Foxton received submissions about the propriety of the order or the basis on which it was obtained or any of the submissions that I'm making to this court today.
Are we talking about the 3rd of April? Is that?
Yeah, there were a number of. There were a number of orders made by Mr. Justice Foxton in April. Yes, and some of them are. I think the
This
court
is
has
on your client's application for an expedited committal hearing.
Was actually mine.
session.
No, it was
I'm
my...
sorry, on their application for an expedite and your client's application to purge his contempt.
Yes.
Is that what we're talking about?
Yes, but I think my learned friend wanted to have the trial of the second committal application heard within two or so weeks of the actual issuing of the application notice itself, the originating process, which Mr Justice Waksman thought was possibly a little too precipitate given the consequences of a committal. There was also an application made by Lakatamia before Mr Justice Waksman where they sought some kind of tagging order whereby he'd be the subject of an electronic tag, which the effect of which, as Mr Justice Waksman put it, in dismissing the application, would be to necessarily, I can't pretend to tell you the precise circumstances, but I can tell you the outcome. The consequences of that application, had it been successful, would have been to confine Mr Sue for 22 hours a day in his flat.
It didn't happen. It didn't happen.
It didn't happen. Mr Justice Waksman took the view that was out with the court's jurisdiction. So those orders were made. It's said by my friend, well, look, Mr Justice Waksman didn't demur. Of course, that was in April 2020, 3 months or less than 3 months after the original order made by Mr Justice Waksman. The order is made then, the search order is then made, as I've explained. It is executed. And as I understand it, a vast cache of documents is revealed which the claimants want to read through, and they put in place some kind of mechanism whereby an independent lawyer reads through in advance for privilege and relevance, and paid for by Lakatamia, and I think they'd say quite a lot of expense for this.
I think that's mandatory under the rules.
Well, it may well be. No, it may well be. But that, and I think the point made by Lakatamia is that this takes an inordinate amount of time. They're having to, and it's very expensive, and reading 800,000 documents takes up, on any view, a lot of time, and that necessarily postpones the means hearing. Is the point made by my learned friend, and therefore, well, if the means hearing is postponed, then the passport order has to be postponed as well.
Can I just be clear? I don't want to spend any time on it, but do you accept that the continued postponement of the means hearing was justified in the light of those developments?
It's very difficult for me to make a submission on that because the evidence in relation to the means hearing is not. I've not seen it. I've not read it. It's not before this court. No doubt there was a very substantial affidavit or witness statement sworn and relied upon by Mr Justice Andrew Baker. There was no doubt an awful lot of procedural correspondence, which I simply have never read and haven't seen, which is not before the court. So I can't accept that. I'm not suggesting that it didn't take a long time to read 800,000 documents. What I am suggesting, though, my lord, in answer to your question, is that Mr Justice Waksman's order was not, there shall be a means hearing, and there shall be, by way of adjunct, a passport order, and that means hearing may be listed, may require to be listed for way into the future, because who knows, the claimant may want to take all sorts of other steps in terms of search orders and other applications here, there and everywhere in order to gird itself with as much documentation as possible to make the second means hearing as efficacious as possible. That's simply not the nature of the order made by Mr Justice Waksman in January 2020. And a root and branch submission I make to this court is that when an applicant says, I wish to list another means hearing, and I wish to have a passport order requiring the person to be cross-examined to remain in the country until that means hearing, there is then a free pass to the applicant, the claimant, to then say, well, I want to take step A and step B and step C in order to track down all sorts of documentation so as to have a more perfect means hearing. And if that requires me to spend 2 years in the process, then the passport order just jigs along in its wake.
But
and I just don't accept that.
That wasn't the order which Mr Justice Waksman made, though, because he ordered, as we've already seen, that there should be a means hearing ASAP.
Well, that's exactly my point, my lord. That's exactly my
the
point.
reason there wasn't was because Mr Justice Butcher adjourned the hearing.
And as will be said against me with Mr Sue's consent, but I don't think Mr Sue was consenting to the passport order being... Let me make this submission, because it may be a point made against me, that when Mr Sue consents to the adjournment of the means hearing, he is not consenting to the continuation of the passport order. He's not acquiescing in the passport order. He's not saying, I quite accept the passport order must continue and I'm very happy for it to continue. For it to continue.
Well, it didn't arise because the passport order would continue unless varied.
Well, that's certainly true because it was, by way of court order at least, it was interlinked with the means hearing. My lord, in terms of further events, what I do know, and I'm speaking from a position of relatively imperfect knowledge, because I'm fully aware that there's a huge amount of material generated over the last year and a half, which is not before the court and which I've never read. What I do know is that Ashfords, who are my solicitors today, came on the record in late April. And that's a point, my learned friends, that particularly want your ladyship's and my lord to know. They came on the record, as I understand it, on the 25th of April of last year. And this is a point that was made in correspondence earlier this week, and which has been answered in that clip of correspondence the respondent was very keen we put together, and which we dutifully and diligently, I hope, did put together, which is part of the panoply of material which is put before the court. And one of the points is made, well, Ashfords were on the scene, why weren't they agitating? They could have brought it on. Now, Mr Crichton, who sits behind me and was, I think, technically the partner in charge last year, wrote a response to that yesterday or the day before. It's in my lady's clip, and essentially says, well, look, we came on the record, we had limited funds, we were inundated with a massive interlocutory material, there was the search order, there were all sorts of other applications being made, we were firefighting, we were being told by Hill Dickinson, you've got to respond to this within by return, you've got to respond to that by return, we insist on X, Y, and Z. We rapidly ran out of the funds we had, and in fact we're way out of pocket, Ashford say, as regards the work we did do last year. They wrote, what they did do in June is write an email, which is in the clip, I don't take the court to it, but it's in the clip that was sent through yesterday, as prepared by us, in June of last year, saying, you've got to bring this application on, this passport application on. The point which I'm advancing to this court now. Now, it's right to say that Ashfords did not formally make an application on behalf of their client to go before the court and say, this means hearing has to be listed now because the passport order is becoming increasingly oppressive. That is right. That is right. But Ashfords were not flush with money. They weren't like Hill Dickinson, who have the benefit of a very wealthy client behind them, and Hill Dickinson have been running this very diligently, I'm sure, and I say nothing against them. But one does need to bear in mind the realities of the situation, as I suggest. Now, the next point that happens in time, and I'm saying this because I don't want it to be said that I've merrily and glided over points that are against me. The next point that happens, and can I invite the court now to pick up the clip of correspondence and documents that came with my learned friend's supplemental skeleton yesterday, which I think the court may have been looking at before the short adjournment. The next thing that happens is that we're now into September, and it's page 1 of that little clip that accompanied my friend's skeleton of yesterday. I'm sorry to be jumping around. It's just the nature of the situation I find myself in.
Yeah. So what are we looking for?
It's a little clip, the first page of which is headed Hill Dickinson. It's a Hill Dicks letter.
What of the 17th of September?
My lord has it.
Yes.
Absolutely right. Thank you. Now, this is a letter which I think my learned friends were keen for the court to look at, and therefore I show it to them. And this is their letter to the judge in charge of the commercial court list, or the commercial court rather, which it's a lengthy letter, but it is essentially saying, for reasons that are explicated at paragraphs 1 through to 7, we can go straight to paragraph 8. In light of the foregoing, Lakatamia does not intend to seek to list the further cross-examination of Mr Sue as to his assets under CPR Part 71 until such time as the review of disclosure obtained under the search order is further advanced. The point being, we've got a massive documentation, we've got to read it, we need time to do it. Put more eloquently than that, of course. The corollary of this is that Mr Sue will have to remain in the jurisdiction and continue to report to the police station or a police station. And then a substantial imposition, he's not acted to seek a listing of the hearing himself. He's applied to the English courts to administer his bankruptcy. There's a pending committal application, which is true. Para 9, if the court receives any further information, we will be pleased to provide it. This letter is copied to Ashford so that if they consider that an earlier hearing under Part 71 is required, they can make the requisite application, which will be resisted. Now, I'm going to try and keep this short. I'm actually noticing the time is creeping up, marching on. There's then some further correspondence in November, and a point that is particularly made against my client is that Hill Dickinson were then thinking about relisting the means application, and Mr Sue wrote a letter to the court, an email to the court, which is again conveniently placed in this clip of documents which my lady has. And if one goes to page 17 of that clip, one will see Mr Sue's response to Mr Hull, the listing officer in the commercial court. Dear Mr Hull, as court is very busy, overriding objective I must consider as COVID-19 and British economy as serious difficulties, this hearing is not urgent. Sincerely, Sue. And I would invite the court to note the email address that Mr Sue writes under, nobu.found.covid19@gmail. Now, it is, I think, in the evidence, and Mr Justice Waksman, in April of 2020, in one of his judgments, makes reference to the fact that Mr Sue was labouring under the misapprehension, and I hope I do him no disservice in saying this, that he had discovered some form of solution to the COVID crisis. It's right to say that if one looks on the internet, and I'm not suggesting the court should do, one will find Mr Sue speaking into a camera about the interconnection between sulphur and COVID.
What's this got to do with anything?
But my point is this. It is being suggested by the defendant, the respondent claimant. Look, we tried to bring it on, and there's Mr Sue making an informed decision. We don't need to have the means hearing. It's not urgent. I'm trying to suggest to this court that Mr Sue is not a well man. Mr Gardner himself, in the witness statement which is before this court, and which was before Mr Justice Waksman, points out that in 2019 he went to visit Mr Sue in prison and was concerned about his mental well-being.
Well, is he capable of giving instructions?
Well, given that I have not spoken to him in the last week, I don't know.
You're not suggesting we should appoint somebody to...
No. I'm not suggesting that, my lord. I'm suggesting this, that the point being made against me is that here's Mr Sue acquiescing in full knowledge of the facts in the postponement of the means hearing. Yeah. Ergo, he is acquiescing in the postponement, or the necessary continuation, rather, of the passport order. And I am suggesting, in the context of a broader submission that I have made in my skeleton argument, which is that where an applicant is in the beneficiary of an intrusive order, such as a passport order, then it is incumbent upon the beneficiary of that order to drive forward the claim, or the relevant claim, so that the order, the intrusive ancillary order, bites as little as possible upon the subject of that order. And I'm not going to take the court to the authorities, they're well known. I have cited in my skeleton argument 2 authorities, one of this court and one of Mr Justice Eder. The first is a very well-known case of Bowmaker, where it was said by the Court of Appeal that if you are the beneficiary as an applicant of a freezing order, then you can't just wait around and just let it sit. You are duty-bound as an applicant to move the case forward at pace. And in Bowmaker, which is a well-known decision, I'm not going to take the court to it, it's in the bundle of authorities. In Bowmaker, the freezing order was set aside. It was set aside for full and frank disclosure breaches, but it was also set aside, as I understand the judgment, on the basis that the claimant, having obtained the freezing order, basically sat on their rights for 2 years or so. And that gives rise to a general proposition, in my respectful submission of law, which is that anyone who's the beneficiary of an intrusive order, such as a passport order, really has to bring it on.
Right. So when do you say they should have got the means hearing on?
Well, my lord, I'm not sure I need. It's difficult for me to answer that question because I am not privy to the full details.
Well, you can't criticise the delay unless you're able to say to us, look, they could have done this or the other, they could have got it on here, they didn't, they sat on their hands.
Let me confine myself to making this submission. I don't think I need to say they should have got it on in March or April, and they should have got it on well before January 2021, which is the...
They applied for expedition unsuccessfully in November, didn't they?
They wrote to Mrs Justice Cockrell, who, it may be my lady has there's an email from Mrs Justice Cockrell's clerk.
Where's that?
Page 5 is the letter, 20th of November. I'm sure Mr Phillips is going to take us through this, but that's the Hill Dickinson's application for expedition, and then Mrs Justice Cockrell's clerk, in an email, refuses that at page 26 of the same clip.
That's quite right, my lady.
So,
well, she doesn't refuse it so much as say. Remember, what she's refusing, my lady, is she's not positively continuing the passport order with full knowledge of the passport order's effect on Mr Sue individually.
but as I say, I thought the whole emphasis of this letter was the passport order, which was part of the basis for the request for expedition.
That as I understand is right.
And it's very apparent from this that Hill Dickinson were acutely aware of the obligations on their client to press ahead with this in the circumstances of the relief which they'd been granted against your client in terms of restricting his movements and all the rest of it. See para 3D, for example. So, like my lord, Sir Nicholas Patten, I think it's an impossible submission for you to make without being able to say they were, well, you say by January, despite this letter, by January they should have had the hearing.
Well, what you can't say in my respectful submission is, oh, well, we wrote a letter to the clerk of the lists or to the senior judge and in what was 11 months or 10 months after the passport order had been obtained. Because we received back the email, which is at page 26, therefore the passport order has remained a proper order and a proportionate order and is within the bounds of the order as originally made. Now, it might mean that the passport order has to be set aside at that stage, even if the second means hearing is not to be listed. Your Lordship will recall the application for expedition is for the means hearing. That carries in its wake, on the basis of Mr Justice Waksman's original order, the continuation of the passport order. But what is not being decided there is that the passport order is properly continuing on its own terms. What is being decided by my lady, Mrs Justice Cockrell, as I read page 26, and I should say I only saw this email for the first time yesterday. I'm not blaming my learned friends for 1 second, but just in the particular circumstances I'm in, this is when I first saw them. Sorry?
I'm just asking a question.
Mr Grant, in that email at page 26,
yes.
It is said, isn't it, the basis for seeking this expedition appears to be that the current reporting and travel restrictions are prejudicial to Mr Sue, So that was the basis for expedition.
Yes.
It's not, however, explained why those restrictions could not be modified at least. And no doubt you take heart from that and say, but they didn't do anything about any modification.
No, I can't go as far as that, though I'm grateful for my lady's comment. I can't go as far as that because there is then an order at page 29, which is the order of Mrs Justice Cockrell of the 21st of December,
Yes.
where what happens there, this is page 30 and 31, is that the Waksman order is modified to the extent that instead of having to go to Charing Cross Station, police station 7 days a week, he has to go to Charing Cross Station 2 days a week. That was an order made without Mr Sue being represented or appearing, page 30.
But no doubt on notice.
I'm not suggesting it wasn't on notice. I don't know why he didn't appear. I don't know why he wasn't represented.
Thomas did appear.
I'm told that the recital at page 30 is erroneous in the sense he did appear in person. By that time, I should say, I don't know what submissions were made on that hearing, but by that time, the application which came before Mr Justice Waksman had been issued. It was issued, I believe, on the 7th of December. And was not, but it wasn't before Mrs Justice Cockrell, of course. It came before Mr Justice Waksman a month or so later. Now, I may have given an imperfect account of all the vagaries of the procedural steps that have been taken over the last year and a half. And no doubt my learned friend will correct anything I have.
That's 7th December 2020. The one that eventually resulted in the order of the 21st of January was issued on the 7th of December.
I believe
And
so.
what's the 14th of December then?
That's the date of the witness statement in support of the application on the 7th. If the court would turn to page 61 of the core bundle, one will see the actual application notice that founded the hearing before Mr Justice Waksman. Tab 9, page 61.
Okay, thank you.
And the court will see it in box 3, the order that was sought, and it was supported by the statement at tab 10. Now, the court, I suspect, has read carefully the judgment of Mr Justice Waksman of the 21st of January, the judgment effectively appealed against. And that is in the bundle at tab 8 of the same file, the same and only file. And in the time available, I wasn't proposing to take the court through it unless the court would be assisted by me doing so. I was going to now turn to my 3 grounds of appeal.
The order is, just a minute, his
Tab
order
13.
is tab...
Tab 7.
7, yeah.
Tab 13 is the original order, so sorry. The order appealed against is actually tab 7. It's a very short order.
Simply dismissing the application we've just seen and fixing a date for the Part 71 hearing.
Yes.
Yeah.
And let me remind the court that the hearing that was listed on the 14th and 15th of April before Sir Michael Burton, the claimant itself then sought to adjourn further, albeit my client consented to the adjournment of the hearing, of the means hearing, while seeking again the discharge of the passport order, i.e. seeking to decouple the means hearing from the passport order, which had been originally the subject of the coupling by Mr Justice Waksman in January 2020. and 20. So I turn to my three grounds. Now, as recast by me and my juniors last week. The first ground, which we have, and the court may recall, I've tried to sort of strip out ground one into two separate grounds, but for ease of exposition. The first ground essentially is this, that when the court is making an order or considering an order, as Mr Justice Waksman was doing in January 2021, 21, not 20, I hasten to repeat, I emphasise, 21, the court is, of course, a public authority for the purposes of Human Rights Act, and therefore it must, as a public authority like any other public authority, not act in a way which is inconsistent with a person's rights under the ECHR. And therefore, when making any order in January 2021, the court was required to take into account Mr. Sue's Article 8 rights and ensure that any interference with those rights was justified by law. Now, can I just invite the court to look at Article 8, which is to be found, my learned friend's Respondent's bundle, which we were looking at just now, we can put aside. And I invite the court to pick up now the first original authorities bundle, the one which has Finucane as its starting point. Article 8 is at tab 16. There are a number of materials at tab 16, including the Human Rights Act itself. But I don't believe this is paginated, this bundle. I should say I did not create it. It was already created before I came on the scene. So towards the end of that tab, the court will see a document headed Schedules. These are schedules to the 98 Act. And this may be, Article 8 may be being looked at by my ladies and my lord on a daily basis, and forgive me if I'm going over very old ground. Article 8.1, everyone has the right to respect for his private and family life, his home, and his correspondence. I interpose, before looking at Article 8.2, to say this, that because a person is a contemnor, or because he is somebody who has not met a judgment debt of this court, does not somehow mean that he has or she has no right to respect for their private and family life. Of course, when one comes to 8.2, there is an acceptance that those rights can be interfered with in certain circumstances, except such as is in accordance with the law, and the court can read on, and I'm sure the court has read those words many times before and has received the benefit of rather more learned exegesis than I can, as a non-human rights lawyer, as I immediately concede, can give to the court. Now, in accordance with the law, has two applications and meanings in this case, I suggest. The first relates to what is now my third ground, i.e., the court knowing that if it makes this order, i.e., an order which keeps a person in the jurisdiction, must take into account the fact that by doing so, on my case, the court is putting that person in breach of the criminal law. And it is my submission, as I'll elaborate a little further down the line in a little while, that knowing that making that order would necessarily put Mr. Sue in breach of the criminal law, it could not have acted in accordance with the law for the purposes of those words that I've shown the court at Article 8.2. But the phrase in accordance with the law has a second meaning, which is that any infringement of a person's private and family life, if it is to be justified, and I put aside the criminal point, has to be justified by reference to what is described in the Bank Melat case, which is in the court's bundle of authorities which we put in, which is proportionate, as Lord Sumption had it in Bank Melat. Now, I've no doubt that very learned people have spent a long time thinking about what I have described as the proportionality analysis or test, and I don't have the time to embark upon that. We have quoted in our skeleton argument paragraph 20 of Lord Sumption's judgment in Bank Melat, and I don't propose to take the court back to the case, other than to say that what Lord Sumption envisages in that decision, with the commanding the majority of the Supreme Court, indeed I think the totality of the Supreme Court, is an exacting analysis, as he puts it, of whether the infringement is justified by reference to a series of criteria. We respectfully, and let me say this, it doesn't matter if the person who brings the application doesn't urge this point. The obligation is upon the court itself to take the point if it hasn't been taken by the parties. And for that proposition, my lady, I invite the court within the same bundle where we are looking at Article 8 to turn to Re Finucane's decision case, which is tab 1, and paragraph 152 of the decision of Lord Carr.
So it wasn't pressed, Article 8 wasn't pressed upon Mr Justice Waksman?
I think it was.
Right, so why do we need this?
Well, I think it might be said that, and I think it might have been mentioned in one of my learned friend's skeleton arguments, that the point was perhaps not put as clearly as it could have been.
There was a Mackenzie friend, wasn't there?
No. We're now Mr. Underwood. We've got leading counsel now.
But it had been raised by a Mackenzie friend at a much earlier stage.
That is.
I mean, we don't need to go to it, but it had. So Mr. Underwood is now in front of the judge.
Back in January of this year.
Yeah.
You're quite right. I don't. Mr. Underwood, Queen's Counsel, is there. Maybe we don't need to look at Re Finucane's case, but that's essentially what paragraph 152 says. And what we respectfully say, and I'm putting this shortly because I'm conscious of the time, and my learned friend has to have a proper opportunity to make his submissions, is that, and I'm necessarily putting this shortly, is that the court below did not undertake that intense and exacting analysis mandated and required by Article 8, as interpreted and as explained in no doubt many cases, but we've chosen Bank Melat for this purpose. And that had Mr. Justice Waksman, one can't see him doing that at all. That may be because of the representations he received, or the submissions he received from Mr. Sue's counsel. I can't say it one way or the other. But he didn't do it. And in my respectful submission, had he done it, considering all the evidential material that was placed before the court, by way of the witness statement that I've taken some time in showing this court, Mr. Justice Waksman would have been bound, in my respectful submission, to say that this order, this passport order, and one's got to not say, oh, well, the passport order goes along as hand in hand with the means hearing order, and if the means hearing order is adjourned for valid reasons, then necessarily the passport order just runs in its wake. That's simply not the right way of analysing this, in my respectful submission. If that exacting analysis had been undertaken, it would have been concluded, or should have been concluded by Mr Justice Waksman, that the interference with Mr Sue's Article 8 rights had gone way beyond in accordance with the law, in quotation marks. Now,
but the judge did go through the evidence, didn't he? Because,
well,
I mean, he refers, I mean, we don't need to spend time on it, but I mean, he does refer, for example, in paragraph 12 to the fact he doesn't have access to healthcare and all the rest of it.
well, I mean, that's a very fair point to make, my lord, and I actually was going to spend a little time looking at some of the paragraphs of the judgment, and paragraph 12 is one of the paragraphs that I was going to take the court to. What Mr Justice Waksman says there, he said that he has no access to healthcare benefits. That might be so, but he has had the financial wherewithal to instruct leading counsel and junior counsel. That's just a non sequitur in my respectful submission. And in any event, it wasn't him paying for those. He's subject to a freezing order. If he was out of prison, I do not think for a moment it would be beyond his wits to obtain funding, bearing in mind that he was staying at the Dorchester 2 years earlier. Again, the passage of time argument doesn't work. I'm going to come back to that. The epithet squalid, this is at the bottom of the page and over the page 56, has been applied to his flat. But beyond that, he's not now suggesting there's anything specific about his living accommodation which makes it. And let's just pause here. Impossible for him to stay where he is, even if he's not entitled to a tenancy properly in his own name. Well, that suggests that the proper test to be applied is whether, if he's got some sort of roof over his head, then Article 8 is not infringed and everything's all right then. And I don't accept that's a correct analysis of the law. He is, even if he's not entitled to take a tenancy property in his own name, and equally so far as access to healthcare is concerned, says Mr Justice Waksman. First, it's not suggested at the moment that the present order is unlimited. It is tied to a means hearing, so it will come to an end at some point. Well, pausing there, every order comes to an end at some point. If the test for acceptability of an order, such as a passport order, was it will come to an end at some point, then the jurisdiction to make passport orders will have been, by a stroke of a pen of my Lord Mr Justice Waksman, will have been transmogrified into an entirely different beast to the one defined by Lord Justice Fox and circumscribed by the judges ever since. So that is simply not a good point, in my respectful submission. Secondly, says Mr Justice Waksman, there's no evidence put before me of any particular medical condition which requires immediate attention. Again, it's nothing to the point. That doesn't mean that Article 8 is therefore out of court. Now, let me immediately embrace, and let me spend 4 minutes on a point that is a point that is made against me here, which is, and I think a point made by Mr Justice Waksman, which is, look, all these points could have been made back in January 2020 when I made my original order. They weren't, or if they were, I ruled against them and there was no appeal. Therefore, it is improper for Mr Sue to come back for a second bite of the cherry. And that's a point which Mr Justice Waksman makes and which my learned friends urge with vigour in their original skeleton argument. Now, I wanted to address that. When Mr Justice Waksman made his original order in January 2020, as I've said, he was in prison, unrepresented, save by a Mackenzie's friend whose legal knowledge I know nothing about. But one can assume it was not.
He's a retired solicitor.
I'm told he's a retired solicitor. when Mr Justice Waksman made his order originally, as I've said more than once, it was properly envisaged and could be anticipated by Mr Sue that the effect of the passport order would be very limited temporally indeed. And I've shown your lordship and my ladies the order that was made in January 2020. So it would have been pointless to appeal the January 2020 order in circumstances where its likely effect on his life was going to be limited indeed by temporally speaking. And indeed would be limited even further by the fact that he wasn't going to be coming out of prison, and he was going to be in prison for the most of it, because it was made in January. He only comes out in April, and one would have hoped the means hearing would come on shortly thereafter. So in practical terms, the order, the 2020 order...
That's revisiting the abuse argument. I mean, that's exactly the argument against you. Anyway, you say it wasn't worth appealing then, but it is worth appealing now. We won't go back there.
Well, I'd say, my lady, that it is perfectly understandable why a man like Mr Sue, in the position he found himself in January 2020, did not appeal an order which he could properly anticipate would be exhausted within a very short period of time, and indeed a much less short period of time of him actually being out of prison, given that it was most of the time he was going to be in prison, because he was only coming out 2.5 months after the order was made. In any event, my ladies and my lord, the Finucane mandates, this is the decision I mentioned a little earlier, mandates that when one is considering an Article 8 question, one doesn't look at it by reference to what you could have appealed a year ago. One looks at the position as it stands at that moment. It just wasn't good enough, in my respectful submission, for Mr Justice Waksman to say, well, you could have made all these points a year ago, you didn't appeal them, therefore they're shut out to you. And this takes me on to a related but separate point, which is, again, a point that was decided against Mr Sue, which was that in order to make the application he was making, which came on in January 2021, he had to show a material change of circumstance. It's a point my learned friends make as well in their skeleton argument. Now, what Mr Justice Waksman decided was that the passage of time is not a material change of circumstance. And I respectfully challenge that proposition. A passport order, which is understood and anticipated to last a matter of weeks, as it was so understood and anticipated in January 2020, is one thing, and it may have been unchallengeable at that time.
So, sorry, the judge found in terms there had been a change of circumstance. That was his finding at paragraph 27. His point was, yes, there has been a change of circumstance, but the reason for that is your client's own behaviour. So he didn't treat it as being irrelevant or not a change of circumstance, as I read paragraph 27. So I think the premise of your submission is misplaced with respect.
Well,
the only change of circumstance has been passage of time.
I think it's fair to say that he is saying that in order to say there has been no sufficient change of circumstance to warrant the court reconsidering the order.
No.
He's not saying there has been a change of circumstance which allows me to consider my jurisdiction afresh. I think what he's saying, my lady, is that it's to diminish the passage of time as a consideration permitting a reconsideration. And my submission, I may have slightly misphrased it, but the point remains good in my respectful submission, is that Mr Justice Waksman's line, or approach, I should say, was that the passage of time was not a sufficient ground for reconsideration.
Well, that may be right, but he says in terms, see paragraph 28, it is a material change of circumstance. He accepts that. In terms. His point then is, maybe discretion is the wrong word, but as a matter of discretion, that material change of circumstance did not justify variation. because its cause was your client's own behaviour. That's it in a nutshell.
There are two answers to that, in my respect.
Well, am I right about that, on that analysis of those two key paragraphs?
My lady may well be right. I'm not going to. It may well be that, but the point remains. I say that he took the view that the passage of time, even if it was technically a change of circumstance, was not one which merited a reconsideration of the question of whether this passport order had become, whilst it might have been originally a proper order to make, as circumstances were anticipated at that time, had not changed its shape. And I say it had very substantially changed its shape and had transmogrified itself from what might well have been a perfectly orthodox bear and winter order back in January 2020, as events transpired, had ceased to be that.
So you say he didn't look at the passage of time in relation to the passport order in isolation. All he did was look at the passage of time and say, well, that's attributable to conduct, rather than saying the passage of time in itself erodes the lawfulness of the passport order.
My lady has it and puts it rather better than I can, of course. But that is it. And what Mr Justice Waksman didn't do is say, well, look, I made an order which I anticipated would last a few weeks.
And
We're now a year later. What he should have said, if I can put it this way, is this passport order is now longer than any passport order ever granted by an English court in history. It's become an extraordinary order, and where an order takes effect temporally, so that every day that it is in effect, it's changing a person's life and affecting their life, then passage of time is not something to be dismissed as some minor consideration. It's the very essence of the change. And my lady, that brings me on to my ground two.
And we're going to have to be at quite a gallop.
Yeah, absolutely. And I think I can treat ground two quickly indeed, which is simply this, that a bear and winter order is quintessentially an order which has been fashioned and carved by the courts over the years. And it is an order which is quintessentially an order made against a hearing anticipated to take place in short order. It is of very limited duration, to use precisely the phrase of Lord Justice Fox, repeated time and time again.
You'd say it's the very nature of the beast.
I would say precisely it's the very nature of the beast. And by the time we reached 2021, it had become an entirely different thing, and a thing unprecedented in English law, and unknown to English law, and out with any form of jurisdictional mandate provided by Section 37, as interpreted by the judges over the years. So that's my ground two. And it was no answer for Mr Justice Waksman to say, as he said at paragraph 12 of his judgment, that, oh well, there's an end date, there's some light at the end of the tunnel. If that were the case, passport orders could last for years. It's going to come to an end sometime, don't worry. And we see that at work, my lady, at paragraph 25, in the same page that my Lady Justice Carr was at. It is said that his rights to see his children and his elderly mother, though he does not seem to have always had a good relationship with her, are affected. All that is true. They were just as true when the matter was brought before me back to me in January of last year. Now, if that's not an error of reasoning, my lady, because in fact, one can see there that the judge is not treating passage of time properly as a material change of circumstances. He's diminishing it. He's saying, well, you know, my order back in January 2020 prevented him seeing his mother and his daughters. What are you worrying about? What are you complaining about? It was always the case then. Well, deprivation of family life for 2 weeks or 3 weeks or a month while you're waiting to be cross-examined as to your means is one thing. But these are not technical points, my lady. These are human lives. These are human points. Deprivation of family life for a month is one thing. Deprivation for a year, or in fact, much longer is in fact, is an entirely different thing. And let us not pass these points by saying, well, he talks about a material change of circumstances. Let's actually get to the heart of what actually this passport order is doing to this individual. Now,
well, it's in-person contact you're talking about. I mean, the passport order doesn't prevent him using Zoom to speak to his family on the computer, does it?
Perhaps it doesn't.
Well, it doesn't.
Perhaps it doesn't.
I'm conscious of time, but I mean, the Article 8 point is huge, and there are so many things that are being overlooked, it seems to me, respectfully. It's not clear to me at all on the evidence that your client had a family life with his mother. He may have loved his mother, but to say that's family life is without more is completely wrong for Article 8 purposes. Your right to family life is not made out because you love somebody. It's how often you see them. Do you live with them? Do you eat with them? How often do you share activities? We don't know anything about that, nor did Mr Justice Waksman.
Well, I did. Look, the evidence is the evidence. I didn't draft
No,
I've come to this case
that, but
last
am I
week
wrong about that?
to try to present my client's case as best as I can. I may be doing it imperfectly, but I am presenting to the best of my ability the facts as they are disclosed on the evidence. I can't say anything more than that.
But do you accept that on the face of the evidence, for example, about the relationship with your client's mother, does not establish a family life for the purpose of Article 8 with her?
I don't accept that with the greatest respect. He talks in paragraph at page 68 of his love for his mother. I've not had physical contact with her for some time. This is para 40. I wish to see my mother and celebrate events with my family as we formerly did. Mm-hmm. Now, it might have been better to put in. I wasn't advising at this stage.
Basically, the only evidence we have about those things are at page 68 and following.
That's exactly it.
And that's all you can do. You can't make it better or worse. And
Exactly.
and you don't accept that is insufficient for the purposes of Article 8.
I don't.
So,
my lady has it.
That's it.
I can. Would your ladyship allow me 5 more minutes on the final ground?
Yes. It seems that not only I, but also Mr. Phillips will.
Of course you can.
Yes.
Thank you, my lady, and thank you, my little friend. Ground 3 is essentially kind of ground 1 rebooted, if I can use that vulgarism. And what we say under ground 3, which we put into 2 different, we put it in equitable terms and human rights terms. An order which requires a person to breach the criminal law is not an order in accordance with the law, I say, under 8.2. Equity got there much earlier. Equity says, as the Pride of Derby case, which I have cited and which is in my lady's bundle of authority, says, that no order shall be made in exercise of the court's section 37, i.e. equitable jurisdiction, which requires a person to breach the criminal law. Mr. Sue is breaching the criminal law by staying in this country without a valid visa. Now, the answer that is put by, which was put by Mr. Justice Waksman, was to say, well, what does it matter and it's just the same as when a court orders, when Sir Michael Burton, on his first or second or third occasion, orders Mr. Sue to be imprisoned for breach of, for contempt of court. That's just the same. Why, if Sir Michael can do it, why can't I? I put it crudely, but for rhetorical effect. There is simply no analogy to be drawn between the court exercising its section 37 jurisdiction and a court exercising its quasi-penal jurisdiction under the contempt, under the law of contempt. Literally no analogy at all. When the court is exercising its Section 37 jurisdiction, it is exercising what was an equitable jurisdiction, which is subject to multiple rules, which are in part analysed in the Pride of Derby case and Spry and in many other places. So there's simply no analogy to be drawn. Just because a court can send an overstayer to prison does not mean it can ipso facto exercise a jurisdiction under Section 37 in the same terms. So that's the first point which I raise. The second point, which my learned friends raise, is, well, it lay within my client's own ability to regularise his position. Now, it may well be that I've already addressed the court on this, and I can treat this relatively shortly. There is, so far as we can see, and we've looked at the categories, the immigration categories, there is literally not one category which Mr. Sue could bring himself within. And one might think that's something of a relief to hear that Mr. Sue can't do that, because the law might be thought to be, I don't make the submission myself, might be thought to be deficient if he could. My learned friends then resort to their submission of yesterday, none the worse for it being yesterday, which is that, well, the Home Secretary has this residual jurisdiction. And I've made the submission this morning. I mean, I do ask the court, really. I mean, is it likely that this Home Secretary is going to say to Mr. Sue, if he were to make the application, I see your predicament, of course you can have exceptional leave to remain, and that means, of course, you can start working and you can start accessing the NHS and you can start volunteering and you can start entering into tenancy agreements, etc., etc. I say that is, I mean, beyond far-fetched as a submission.
Well, what's I mean, I don't want to prolong all this, but you probably don't know the answer, but I mean, if somebody is committed for contempt, and as a result of that, their visa expires, they can't leave the jurisdiction. I mean, what in practice do the authorities do? I mean, while they're in prison, presumably they don't do anything. But once they come out, they don't then presumably try and prosecute them for having overstayed when they're confined by a court order.
My Lord, when your Lordship said you may not know the answer to that question, your Lordship had it in one. I just don't know. I mean, I have spent a lot of time thinking about the law of committal in various respects, but I don't know the answer to that question.
I'm not surprised.
I just don't know. But that does raise a further point, an almost final point that I was going to address the court on, if I may, which is we can see Mr. Justice Waksman dealing with it at paragraph 10 of the judgment at page 55, tab 8. Which is, this point had been addressed to him.
Yeah, this is what I had in mind about the earlier occasion when it was raised.
Yes, it was raised by Mr. Coleman, the Mackenzie friend, and he says that in terms of paragraph 10. And that breaks down into 2 points. One is, as I said then, and as I say now, I think, putting it in summary terms, it's very unlikely he's going to be prosecuted. Well, there are two answers to that. One is, how does Mr. Justice Waksman know that? There was no evidence about the likelihood of prosecution. I don't know. I don't think anyone sitting in the commercial court would know, without any disrespect at all to Mr. Justice Waksman. Who knows? Secondly, why does it matter? The law is clear, whether as a matter of human rights jurisprudence or equitable jurisprudence. It doesn't matter whether it's likely or not. The second point I have to confront, which I've possibly partially confronted already, is the second bite of the cherry point on this issue alone, which is, well, and this is paragraph 11, Mr. Underwood makes the same argument before me today. There are two problems with this. First of all, nothing has changed in respect to that argument since the last time it was made. And it wasn't open to Mr. Underwood to make the submission at all, and presumably that would, if Mr. Justice Waksman is right, it follows that I'm disabled from making the submission to my lady and the court. Well, Mr. Underwood rightly submitted, in my respectful submission, that every day he's here, he's committing a separate and fresh offence. So it's one thing to force a person to be in jeopardy of the criminal law for 2 or 3 months between January and March 2020, on the basis that was the anticipated date for his second means hearing. It's another thing to force him to be breaking the law for 12 months, as had expired by then, of course. That goes to the likelihood of prosecution, it could be said. It goes possibly to the likelihood, the sentence that might be passed. Presumably an overstayer who's been 12 months an overstayer, or even longer, is likely to be met with a harsher sentence than somebody who's been 3 months or 2 months an overstayer. But my submission is that simply saying this point was raised a year ago, there's an end of it, is wrong. And because it engaged Article 8, Article 8 does not permit sort of raised judicata points. The court had to consider this man's position as it stood in January 2021, not as it stood in January 2020. And finally, I think it's proper to point out what was he says this: I do consider, this is paragraph 11, I do consider I'm entitled to look at the practicalities, because if Mr. Underwood is right in suggesting, as he faintly did at one point, that my original order might have been unlawful, then any stay in prison after he was an overstayer would be equally unlawful. It's a most surprising proposition, and only needs to be stated to be rejected. Nothing in the deportation point. It wasn't a deportation point, it was a criminalisation point. I've troubled the court long enough. I've received indulgence from the court, and I'm grateful for that.
Can I ask you just one little footnote point? If you're right, and there wasn't, the judge was required to, and B, the judge did not carry out the type of Article 8 proportionality review that he should have done, is the consequence of that, assuming you, as I say, you persuaded us on that point, is the consequence of that that we allow the appeal and set his order aside, or is the consequence of that, because the judge has failed to act in accordance with law, that we have to do that to decide whether or not his order should stand? Or a third possibility is that we remit it back to him to do that. I mean, what's the outcome of you being right on that point?
The outcome is you allow the appeal, because if you start, I'll tell you why. That is the answer. Because because of the ultimately temporal nature of the order, so that every day that passes is an actual imposition on a person's life. If you were to say, well, 6 months later, here we are in July 2021, we're now going to remake the order. My client can't get his 6 months back. They've been lost to him forever in one sense. What the court can do, of course, the court, your lordship and my ladies can't give him back 6 months of de facto freedom. I accept that. Of course, those days have passed and are lost forever in one sense. But what the court can do is say this order was unlawful in January 21. That might, as I've already explained before the short adjournment, have potential consequences in other scenarios and other situations. What I would urge your lordship not to do would be to say, well, let's just revisit and rework all the arguments which were advanced in January 21 and revisit them in July 21, not least because other events have occurred, and I can well envisage your lordship might think, well, let's reconsider the point now. The passport order has de facto happened and been in force for every day since January 21. He's now in prison. What's he worrying about?
No, but the reason I ask you is because conventionally, if, for example, you're hearing an appeal against an injunction, and I know this isn't an injunction, but it is nonetheless the exercise of discretion under Section 37, and you find the judge has misdirected himself, then normally this court then has to carry out the exercise of the discretion itself in deciding whether the order should be allowed to stand. I mean, I entirely accept, Mr. Grant, that raises the other problem, which of course is that you're then left to exercise the discretion now, not
That's
6 months or
problem as
whenever
I
it was.
perceive it.
And that sometimes requires further evidence and can cause all sorts of problems. But I just wanted to know what your submission was.
I think I've given the best submission I can on that. I can see the difficulties that your lordship is
yeah.
raising.
Okay. Thank
But
you.
if the court were to come to that conclusion, then I think, cognizant of what my Lady Justice Carr has intimated, I might want to seek permission, and of course this involves all sorts of suppositions which I'm in no position to make, to put in proper evidence or better evidence or fresh evidence.
All right.
But that's of course not a submission you'll
Well,
of course
it's perhaps
need to
a
make a
point
ruling
that
on or
can
come
wait
to a
to a
conclusion on
later time.
now. I'm going to turn my back on the court if I may. Thank you very much. Unless I can assist any further, of course.
Mm-hmm.
Thank you very much indeed. Mr. Phillips.
I have limited time, evidently, but it's proper, I hope, that these matters have been ventilated at length by Mr. Grant, given that he is the appellant. I'll just deal with Sir Nicholas's last point, if I may, first. If the order that was made by Mr. Justice Waksman appealed against is ultra vires, then the court must allow the appeal.
Of course.
If the learned judge misdirected himself in the manner that Mr. Grant urges, then it is for this court, in the light of matters as they now stand, to re-exercise the discretion that was available to him on the basis of the evidence which is before the court today, in accordance with Section 37 of the Senior Courts Act. But my lords, my ladies, my lord, could I, things are going to be out of order, for which I apologise. Could I just show the court that Mr. Justice Waksman, although it may not have been expressed in the terms directed by Lord Sumption in the Supreme Court, was in reality carrying out a balancing exercise by reference to the submissions that were then urged upon him by Mr. Underwood and are repeated today by Mr. Grant. If your ladyships and my lord go to Mr. Justice Waksman's judgment at tab 8, and if the court goes with me to paragraph 22 of that judgment, the learned judge below said this: nonetheless, Mr. Underwood says that, to the extent that there is utility, and he means utility in the means hearing.
Sorry, which paragraph are you
Paragraph 22, my lord. I'm sorry.
Right, thank you.
To the extent that there is utility, it has to be balanced against the interference with Mr. Sue's rights. Some of those matters I have dealt with, namely the question of being an overstayer and the question of access to services and the questions where he is living. And then what he does is he goes on to deal with the other points that were urged on him by Mr. Underwood, which are urged upon this court by Mr. Grant. And in my respectful submission, the criticism of the judge that he was not engaged in a balancing exercise by reference to all the factors which are relied upon for the purposes of this appeal is an unfair criticism of the judgment below. Going, if I may, to deal as quickly as I possibly can with 4 areas. Firstly, the nature of this appeal and the review exercise upon which the court is embarked. Secondly, insofar as not already dealt with by my learned friend, and I'll attempt to take it quickly, the chronology from the 30th of January. And I do that because it's scattered across a number of places because of the character of the appeal. Thirdly, insofar as I have time, the judgment below. But the principal point is the point that I've just addressed, namely that the criticism of the learned judge is unfair. And fourthly, the proportionality test. And really there are 3 points which I'll headline now. First, the passport order has never in fact had any operative effect as a matter of law, because at the time that the matter came before Mr. Justice Waksman in January of this year, whether or not he had been released, Mr. Sue was still subject to a custodial sentence. And I'll show your lordship, your ladyships and my lord, the relevant section of the 2003 Act. Secondly, the reality of the position is that Mr. Sue has consented throughout until the 7th of December to the proposition that the restrictions on his liberty should remain in place because he was well aware that those were tied to an effective second means hearing that was granted by the order of the 30th of January 2020. Well, in fact, there is no third point. So it'd be those 2 points.
What's the best submission?
Well, there is a third point, but I can't read my note. Now, firstly, therefore, the exercise upon which the court
Is it something
embarked.
about private and family life? Was it something about private and family life?
It is proportionate given the circumstances, is what my note reads. But precisely what that is going to mean when I get to the third of those points is a matter for debate.
So we're on your first point, nature of the appeal.
The nature of the appeal. And I just want to remind the court, if I may, of the review exercise upon which the court has embarked. I'm going to do that by reference to two passages from two authorities. Those are, I think, both in the supplemental authorities bundle that arrived with the further skeleton argument yesterday. It's entitled Respondent Supplementary Authorities, I hope.
It's the small one.
Could I take the court firstly to the judgment of this court at tab 4 in News Group newspapers. It seems that I've already managed to give myself a wrong reference. Would your ladyship just give me a moment?
Mm-hmm.
Paragraph 26 of the judgment of the Master of the Rolls. Now, this was the issue that was before Mr. Justice Tugendhat was, of course, an issue concerning the publication of private information. And what the Master of the Rolls says at 26 is nonetheless directly relevant to the exercise that this court is embarked upon. And what the Master of the Rolls says at 26 is that whilst that decision did not involve the exercise of a discretion, it involved a balancing exercise with which, at least as a matter of general principle, an appellate court should be slow to interfere. When considering an appeal against such a decision, an appellate court is normally exercising a review function. I pause there to say that there's been no application that this appeal proceed by way of a rehearing, and should not allow the appeal unless satisfied that the judge was wrong. As I said in Flood and Times newspapers, where the determination is a matter of balance and proportionality, it is, generally speaking, difficult for an appellant to establish that the judge has gone wrong. All the more so where, as here, the judge is very respected and highly experienced in the particular area of practice and has given the issue very careful consideration. Now, just pausing there, Mr. Justice Waksman is not the only judge of the commercial court to have considered the appropriateness of the restrictions to which Mr. Sue is subject. We've set it out in writing, but relevantly, those restrictions were considered by my Lord Mr. Justice Foxton on a number of occasions, principally last April, and if my learned friend is right that the court of its own motion should consider whether or not Article 8 is engaged, although that he was not directly addressed on the point, he had no difficulty whatsoever with continuing the restrictions to which Mr. Sue was subject in all of the proceedings that were taken during the course of April. Those restrictions were effectively again considered by my lady, Mrs. Justice Cockrell, in the commercial court in December of last year, and I'll come on when we come to deal with the chronology with documents that I know the court has already seen, and in particular with her direction in relation to the expedition of the cross-examination as to means that was sought by my client. But, and I am not seeking here to, I hope, to stray into illegitimate territory, the restrictions were again considered after Mr Justice Waksman had made his order in January of this year by Sir Michael Burton in April, and your lordships, my lord, have the judgment of Sir Michael at tab 12 of the original authorities bundle. And he again, as the court is already aware, directed that the restraints on Mr Sue's liberty remain in place until the 31st of July this year. And so if Mr Justice Waksman fell into error in January of this year, he is, in my respectful submission, in very good company. In that, if one includes in that list Mr Justice Popplewell, as he then was, and Mr Justice Bryan, albeit that those orders were made when Mr Sue, either before Mr Sue entered the jurisdiction or shortly thereafter, that's a third of the commercial court bench that has got this wrong on my learned friend's submissions. Now, the other case, it may be that we don't need to go to it because I'm pretty sure the court's going to be familiar with it, is the judgment of Lord Justice Thomas in Aldi. But again, that is in the original authorities bundle at tab 2. And I'll just remind my ladies, my lord, of what was said by Lord Justice Thomas, as he then was. Tab 2, Aldi, paragraph, I hope, 16. Considering the approach taken by the court to the decision of the judge, it was rightly accepted by Asplin that the decision to be made is not the exercise of discretion, and WSP were wrong in contending otherwise. It was a decision involving an assessment of a large number of factors, to which there can, in such case, only be one correct answer to whether or not, there is or not an abuse of process. So it's different territory, but what the learned Lord Justice then said is of relevance. Nonetheless, an appellate court will be reluctant to interfere with the decision of the judge where the decision rests upon balancing such a number of factors. See the discussion in Assicurazioni Generali. And he goes on just below letter D. The types of case where a judge has to balance factors are very varied, and the judgments of the courts as to the tests to be applied are expressed in different terms. However, it is sufficient for the purposes of this appeal to state that an appellate court will be reluctant to interfere with the decision of the judge in the judgment he reaches on abuse of process by the balance of factors. It will generally only interfere where the judge has taken into account immaterial factors, omitted to take account of material factors, erred in principle, or come to a conclusion that was impermissible or not open to him. And in my respectful submission, none of those apply in this case, as indeed can be seen from my Lord Mr Justice Waksman's judgment. Chronology, the second of the headings. The court has already looked at this, but the starting point, unless one goes back to the judgment of Mr Justice Cook, and in fact there were two judgments consequent upon that, one in late 2014, one in 2015. Unless one goes back to that point, the relevant chronology for the purposes of this appeal begins with Mr Justice Waksman's order of the 30th of January 2020. Your Ladyships, my Lord, have looked at that, and unless it's necessary, I won't go back to it, but it's at tab 13 of the original bundle, I think, at pages 95 to 96. Now, it is true that at that point Mr Sue was in custody and that he was represented by a Mackenzie friend from whom the judge gave permission that he could hear from the Mackenzie friend directly, although my recollection is that Mr Sue also addressed him. But as the judgment makes clear, the principal argument, which is ground one of the grounds of appeal, namely, and it was reiterated now as ground 3, namely that the order requiring Mr. Sue to remain here and thus making him an overstayer was an issue that was addressed by Mr. Coleman on behalf of Mr. Sue at that stage. So that's how matters stood on the 30th of January 2020. But what is, of course, notable from the order there made is that Mr. Justice Waksman was persuaded at that stage that it was entirely appropriate that Mr. Sue exceptionally be required to attend court for a second examination as to his means and assets in accordance with CPR Part 71. And that is not challenged. One of the difficulties overarching everything which my learned friend urges upon the court is that the passport order is necessarily tied to that hearing taking place, and yet it is accepted that there are no grounds upon which the necessity for that hearing to take place can be challenged. Now, the two are tied intimately, can I make this point, for the reasons given by Mr. Justice Foxton in relation to Mr. Sue as a flight risk. Could I show the court what Mr. Justice Foxton said about that in one of his judgments? This is in the supplementary bundle that came with the skeleton argument yesterday at tab 7. It's a judgment reported in the weekly law reports. And
so, sorry, we're
In the thin bundle.
thin, perhaps blue, my lord.
yeah.
Respondent supplemental authorities. I hope
Which
it says.
tab is it?
Tab 7, my lord.
Thanks.
Now, the learned judge was dealing with, amongst other things, applications for various applications for disclosure, I think, and various other matters. But the passage that I wanted to take your ladyships to and my lord to is paragraph 81, where Mr. Justice Foxton said that he found on the evidence before him that Mr. Sue represented a significant flight risk, and then recorded some of what that evidence was. There have been clear attempts by Mr. Sue on repeated occasions to avoid orders of this court and attempts to enforce those orders by leaving this jurisdiction. And the evidence before me, and then he recites it. Now, the first one is Mr. Sue's absconding from the Gare du Nord when he was on his way to the world premiere of the film in which he starred, which was paid for contumaciously in breach of the freezing order. It's a film called The Outsider. The second, Mr. Sue gave a false address when he was served with the Popplewell order at Heathrow. That's when he arrived in the jurisdiction.
That's the wrong hotel.
Yes, he gave what he did. He was obliged under Mr. Justice Popplewell's order to say where he was going to be. He said the Dorchester
And went somewhere else.
and went to the Intercontinental. And then, as your ladyship sees from the next sub-paragraph, there was the extraordinary incident when he got into a taxi, went to Liverpool in an attempt to flee to Northern Ireland and then cross the soft border into Eire. But he made the mistake of arousing the suspicions, as my learned friend said, of the check-in staff of Stena Lines. They called the police. His name was run through the PNCR, and he was brought down to London the next day to appear in front of Mr. Justice Bryan. Mr. Justice Foxton deals with that at 4, rejecting Mr. Sue's evidence that he panicked. But then he records the fact that there has been no desire in Mr. Sue's, there's been no change in Mr. Sue's desire to thwart orders of this court in the meantime, as is apparent from the judgment of Mr. Justice Jacobs in Mr. Sue's first purge application and the judgment of Sir Michael Burton when sentencing Mr. Sue to his second period of imprisonment for contempt. the first of those hearings before Mr Justice Jacobs, it became clear that Mr Sue was not at all intent upon purging his contempt. He wanted to appeal by the back door after this court, including my Lady Justice Asplin, had denied him permission to appeal out of time against the first committal. Mr Justice Waksman then records that Mr Sue faced a further committal and finally records that he can place no reliance on Mr Sue's suggestion that he has no motivation to flee. His own submissions on this issue referred to his concern for his mother, who lives in Tokyo. Well, Mr Sue himself refers in his evidence, as the court has seen, to a somewhat strained relationship with his mother, which, having cross-examined her for 5 days in January this year, I can tell the court is a minor understatement. I'll add also, by reference to the evidence in this case, this is the point raised by my Lady Justice Carr, was the court knows, obviously, that Mr Sue's elderly mother resides, it's not at the moment actually in Taiwan because of the pandemic. There was, well, I'm told by Mr Contempt, Japan, it's one or the other, I can't remember. There was a family home in Japan which was shared between Mr Sue's mother, who was known as Madam Sue, who owned the house and 15/26 of the land, and Mr Sue himself owned 11/26 of the land. This was the contempt hearing last week, in part, because that asset of Mr Sue's was never disclosed. In the proceedings against his mother, Sir Michael Burton made a freezing order ex parte against Madam Sue, which was then discharged inter partes, and then had to be subsequently restored by this court. But in the interim, and this is a matter of public record, the family house was sold by Madam Sue, although Mr Sue retained 11/26 of the land. The point here is that the court does not know from the evidence which is before it on this occasion where Mr Sue says his home is, nor where his settled purpose of existence is said to be. When his mother gave evidence to Mr Justice Bryan in January of this year, she described him as a flying man, by which she meant that he was an international businessman and the chief executive of the family companies. But the only point that I'm making at the moment is, in circumstances where it is urged upon the court that there is a settled family life elsewhere, the court may well feel that it is entitled to be told both the nature and character of that alleged settled family life and where it is.
And private life.
And private life. And where it is. Now, my ladies, that's been, as it were, an aside. I was on the chronology. I've dealt with the 30th of January. On the 11th of February 2020, the second committal came on. Mr Sue, who was already in Pentonville, was found to have committed a number of further contempts, including, by way of example, not disclosing in a number of freezing injunctions and on his purge application in the face of the court that he was the owner of 3 apartments in Central Park in New York, or around Central Park in New York, and Sir Michael Burton on that occasion sentenced Mr Sue to a further 4 months. On the 25th of March 2020, Mr Justice Butcher adjourned the means hearing, but he did so, although the order does not record this, in circumstances where Mr Sue had consented to that adjournment. What he said, and I think the relevant document has now been sent by Hill Dickinson to those instructing my learned friend, is that it seems unlikely to be an effective hearing. And what Lakatamia has always said about that, apart from his having consented to the adjournment of the means hearing, is that that appears to be an acknowledgement that it couldn't be effective because Mr. Sue had not produced any of the disclosure that he had been ordered to produce by Mr. Justice Popplewell, Mr. Justice Bryan, and I think one other judge, but I forget whom. I'm told, no, that's later. Oh, and Mr. Justice Tier. So that's the 25th of March 2020, and the hearing is essentially adjourned by consent. On the 3rd of April 2020, Mr. Justice Waksman continued the restrictions to which Mr. Sue was subject. That was in anticipation of the fact that Mr. Sue was shortly due to be discharged from Pentonville in accordance with the duty of the Secretary of State under the Criminal Justice Act. Now, that order was attached to the skeleton with which we provided the court yesterday, and it is page 12. The judgment, I can see my lord reaching for it, so I'll just go quickly to it. There is the order of the 3rd of April. And if your lordship goes, and my ladies go to paragraph 7, the restrictions on Mr. Sue's liberty were continued at paragraph 7. That is 6 days before Mr. Justice was released by the Secretary of State. That occurred on the 9th of April 2020. Now, in that regard, I will attempt, I'm afraid I'm going, given what my learned friend said earlier, I'm going to have to show the court section 258 of the Criminal Justice Act, which was in the original authorities bundle at tab 17.
It just can't be right that you lose the extra year. The extra year just disappears.
Well, if your ladyship is with me on that.
No.
But, I mean, it isn't right. Section 258 of the Criminal Justice Act. 258, section 2, subsection 2, as soon as a person to whom this section applies has served 1/2 of the term for which he was committed, it is the duty of the Secretary of State to release him unconditionally. Now, there is no remission of sentence there at all. There is merely a duty on the part of the Secretary of State to release a contemnor at the halfway point. The sentence itself remains the sentence that was handed down against the contemnor. And that necessarily means that throughout the entire period, running up to the order of Mr. Justice Waksman in January of this year, which is appealed against, and indeed thereafter, Mr. Sue was still subject to a custodial sentence. It is simply that the Secretary of State had released him, as she was bound to do, in accordance with section 258 of the 2003 Act. On the 21st of April, shortly after Mr. Sue was released from Pentonville, those who instruct my learned friend came onto the record. Now, once solicitors are on the record, they are essentially the mechanism by which the litigant is represented. And that is relevant to the two letters, or to the letter to which I know the court is aware of it, of the 17th of September, which we're going to come to in a moment. But before we get there, I will just deal with these dates. On the 22nd of April 2020, shortly after Mr. Sue had been released, Mr. Justice Waksman again continued the restrictions on his liberty. That is at page 20 of the small clip of documents attached to the skeleton yesterday. And throughout this period, of course, what my client is attempting to do is to obtain the documents that Mr. Sue has been ordered to disclose in order that there can be an effective cross-examination as to his assets and means. None of that is forthcoming, with the result that on the 17th of June 2020, a search order was made by Mr. Justice Andrew Baker. That is dealt with in Mr. Gardner's 28th witness statement, which is before the court because it was the witness statement made in opposition to this application below, at paragraphs 24 to 26. I'm not going to go to it, but there are two short points. The first point is that it resulted in an enormous quantity of documentation, 800,000 documents.
Well, these were stored electronically on a
There were
computer.
both hard copy documents and electronic documents. The vast majority were electronic documents. Yeah. Now, my client, there's a point made by Sir Nicholas earlier that, as it were, those materials had to be reviewed for privilege before they were passed to my client. In fact, there is no authority that said that. But my client took the view, on advice in which I am not waiving privilege, that it was appropriate for Mr. Sue's legitimate rights, for example, in relation to his privileged documents or documents that were irrelevant to his asset position, it was appropriate for Mr. Sue to have his rights respected and protected by the documents first being reviewed by independent reviewing lawyers. And that in the first instance, the cost of that exercise would have to be met by Lakatamia. And so the court will forgive me if I make the observation that when it is said that we have not sought to look after Mr. Sue's rights throughout this process, legitimate rights throughout this process, that is a submission on which my learned friend was challenged in relation to the date by which it is said we should have fixed the means hearing. That is a submission which we find rather offensive, because this is not the only respect in which we have sought to protect Mr. Sue's legitimate rights. In any event, the documentation was so vast and being reviewed at a rate that would have pushed everything out so far into the future that Mr. Justice Jacobs, I think, gave permission for a second independent reviewing lawyer to be appointed, again paid for by Lakatamia. So that takes us...
we don't need to spend any time. I think what was in the back of my mind it was a long time since I looked, wasn't the requirement for a reviewing lawyer, it was certainly part of what used to be called an Anton Pillar order, wasn't it?
That's what a search order is, my lord.
Yes.
Now, what there is a supervising solicitor.
Yes.
And the supervising solicitor executed the search order in this case on the 18th of June, the following day. My own friend said Mr. Gardner was there, which is where we get Squalid Little Flat from. In fact, he wasn't. His then senior associate, now partner, Mr. Bramwell, was present whilst the search order was conducted. And that is where Squalid Little Flat comes from, I think. But in any event, the search order revealed huge numbers of documents, many of which, of course, should have been disclosed by Mr. Sue in accordance with the obligations to which he is already subject. And at this point, I'll just pause, because it's the same throughout. One, Mr. Sue is subject to a custodial sentence. Two, he has consented to the means hearing, as it were, being pushed back, notwithstanding that he knows the restrictions on his liberty are tied to that hearing. And three, Lakatamia is essentially being prevented from bringing on that means hearing by virtue of Mr. Sue's default. He has only himself to blame. I need to skip forward. Your Ladyships and my Lord will have in mind the letter of the 17th of September 2020 to which no reference was made in the materials that were placed before the court for which permission has been given today. But it is an important letter. And I'm going to deal briefly both with that letter and the letter seeking expedition, again demonstrating the fact that Hill Dickinson have been assiduous in attempting to protect Mr. Sue's rights. Page 1 of the small clip of documents that came with the skeleton yesterday. I don't think the court was taken to paragraph 1 of that letter. But the last sentence, the last 3 lines of paragraph 1, make clear why the letter is being written, given the constraints currently imposed on Mr. Sue pending that hearing, and the terms of the consent order pursuant to which a previous hearing was adjourned, we consider that the court should be made aware of the current situation. Now, this letter was copied, as your lordships see from page 2, to those who instruct my learned friend, who were on the record for Mr. Sue. And at paragraph 9, Hill Dickinson record that fact, and then they say that it is being copied to Ashford's, so that if they consider an earlier hearing under Part 71 is required, they can make the requisite application. Not only was no application made, no correspondence was sent to the court by Ashford's at this stage. We then go on to the 20th of November, by which time the exercise, as is clear from the letter at page 5, with regard to the review of the documentation that Mr. Sue had contumaciously failed to provide, had, as it were, advanced to at least some stage, and an application was made to the court for the expedition and listing of the CPR Part 71 hearing. What then happened, I just refer, if I may, to specific paragraphs. 2 gives the reason why expedition is sought, and again, the reason is Mr. Sue's rights, no other reason. At subparagraph H on the following page, page 6, 3H, Hill Dickinson record the search order, and then, as the court will see in the last sentence, say that the work has been enormously time-consuming and hugely expensive. Attention is then drawn to the previous correspondence of September at paragraph 4. And at paragraph 7, Hill Dickinson say this: considering that Mr. Sue cannot, as matters presently stand, leave the jurisdiction until the further hearing under CPR Part 71 has taken place, and given that he is subject to the onerous obligation that he report daily to the police, Lakatamia respectfully requests that the court direct that the further hearing be listed on an expedited basis. Now, as I know the court is well aware, because we've been to the relevant emails, what then happened was Mr. Sue himself sent an email to Commercial Court Listing to Mr. Hull, in which he said, amongst other things, that the hearing is not urgent. Now, various submissions were addressed potentially with regards to Mr. Sue's health by my learned friend, in relation to which I make 2 points. 1, there is no evidence about that. 2, what there is, because it is recorded in a judgment, another judgment of Mr. Justice Waksman, is that Mr. Sue had previously raised the issue of his capacity before Sir Michael Burton in advance of the first committal hearing, and Sir Michael Burton had ruled that he did have capacity. In fact, we've already looked at the judgment. It's the paragraph 81. It's recorded in that judgment of Mr. Justice Waksman that Mr. Sue, as part of his game playing, had instructed a consultant psychiatrist who was unavailable for the period over which the committal hearing was listed. So that takes us, as it were, to December. And what happened in December was that further to the direction given by Mrs. Justice Cockrell, the reporting restrictions were then relaxed with Lakatamia's consent shortly before Christmas to an obligation to report to the police station twice a week. Now, with regard to what the order made on the 21st of December says, I was not at that hearing. But the reason why it is said that, as I understand it, why Mr. Sue was not present was that the hearing was conducted remotely, and that during the relevant period during which the court discussed with those acting for Lakatamia, I believe Mr. Casey, the relaxation of the reporting requirements, his connection, let's be kind, his connection dropped, so that he was no longer connected to the hearing whilst that matter was discussed. This is not before the court, but what then happened, Mrs. Justice Cockrell having made her order, is that Mr. Sue wrote to the court, or emailed the court, and said that he didn't want the reporting restrictions relaxed. He wanted to go to the police station every day still. I don't know whether he was prevailed upon, but nothing came of that, and the reporting restriction is, or at least was until he was sent to Pentonville again last week, still 2 days a week. Now, that is the position as it stood before Mr. Justice Waksman on the 21st of January. But the significant points are the two that I've already made. Firstly, throughout this period, Mr. Sue had essentially consented to the restrictions on his liberty remaining in place, because those restrictions were linked inextricably to the CPR Part 71 hearing, and he was well aware of that. And secondly, Mr. Sue was, in any event, subject still to a custodial sentence.
Does a continuing custodial sentence prevent you leaving the jurisdiction?
Not if you are not subject to restrictions.
Right.
It's an odd part of the law, of course, because we come at this from a criminal law perspective and look for license conditions, and yet there is nothing in the 2003 Act which enables the imposition of those conditions.
Because, I mean, I don't know a great deal about this, but I mean, there are obviously certain types of sentences where people are released on a conditional basis on a license, where they can be recalled to prison if they breach the terms of their license.
Indeed, and defendants are told in the course of sentencing remarks, at least not in relation to life sentences, as my learned friend said, but in relation to finite sentences, that they will serve half of that time and that they will then be released upon license. But if they offend again during the course of that period or breach the terms of any license that is imposed upon them, they are subject to subject to being recalled to custody.
Yeah.
But this is an oddity, because there are no such provisions in relation to civil contempt laws. But the answer to your question, my lord, is that I don't seek to say that for the second half of the custodial sentence, a contempt law is confined to the jurisdiction unless there is an order to that effect.
Yes. All right.
And my ladies, my lord, I can see the time. The judgment below, I've really made the principal point that I wanted to make, which is that although it may not be expressed in the terms that my learned friend would have it expressed in, the reality is, firstly, that Mr. Justice Waksman considered all the points which are now urged upon the court, and that is apparent from the judgment. And secondly, as paragraph 22 shows, he was intent upon conducting the very balancing exercise which my learned friend says ought to be conducted. Now, with regard to proportionality, which is the fourth of my points, the question the judge had to ask himself, as at the 21st of January, was whether or not the continued restraint was appropriate. And the starting point for that exercise is that there was no challenge to Lakatamia's entitlement to a second and effective cross-examination of Mr. Sue as to his means and assets. Secondly, there had been no challenge until the 7th of December, when Mr. Sue's application was issued. I think it was actually, although it says the 7th of December, it was perfected on the 14th, and I think that's when it was issued. But in any event, until early December, there had been no challenge to the restraints to which Mr. Sue was subject. This, despite those restraints being tied to the means hearing, and despite those acting for Mr. Sue having been invited, if these were his instructions, to make an application that that hearing come on sooner. Those rights, as Mr. Justice Waksman indicates in paragraph 22, those rights of Lakatamia, had to be balanced against Mr. Sue's own rights. Mr. Sue's evidence in this regard is the evidence to which the court has been taken, and I've made my points on that. The only other thing that I would say with regard to Mr. Sue's evidence is that in my respectful submission, it should always be treated with some caution. In 2014, Mr. Justice Cook found that Mr. Sue was an unsatisfactory witness who had lied to him. In the first committal judgment, Sir Michael Burton records that Mr. Sue had lied to him. And last week, which is perhaps the most extraordinary feature of the third committal application, what emerged was that the contempt that Sir Michael had not found proven to the requisite criminal standard on the first committal application had in fact occurred, and Mr. Sue admitted last week that it had occurred, with the effect that the denial that he made when he was cross-examined on the first committal application consisted of lies.
Was this New York Apartments or something else?
No, it's a company called Ocean Net.
Don't worry, okay, so it's fine.
At the first committal hearing, one of the contempts was that Mr. Sue had not revealed in his various affidavits in response to various orders the ownership of a company called Ocean Net. Last week, he admitted that it was his company.
Was this one of the companies that got the money from the Monaco properties?
Oh, no. This is another company, my lord.
Okay, all right.
Those two companies are called Cresta and Portview. And what Mr. Justice Bryan has now found, as against Madam Sue, those companies and two others, is that Mr. Sue, Madam Sue, and those companies unlawfully conspired together to deprive Lakatamia of the sale proceeds of the Monaco villas, over €27 million.
Is there no way of getting your judgment enforced in Japan?
I don't, if I may,
normally
want to go into it.
Oh, all right.
I mean, your lordship can see everything that's going on because it's all in all as it were in the public domain. The problem is that Mr. Sue, and Lakatamia maintains that he's dishonest about this, says that he has no assets. The one asset that did exist in Japan
the home?
Was the family home that Madame Sue sold in the interregnum between Sir Michael Burton wrongly discharging the freezing order against her and this court restoring it. So she was entitled to do that. But what Mr. Justice Bryan found in that regard was that her affidavit of assets, once the freezing order had been restored by the Court of Appeal, was itself dishonest because it made no reference to the fact that this had happened, and that she said in that affidavit that she was resisting the freezing order not because she had any money, but in order to, as it were, preserve and protect the name of the family. Anyway, that was dishonest. As Mr. Justice Bryan found, lies ran through her evidence like a stick of Blackpool, letters in a stick of Blackpool rock. Now I'm on the balancing exercise. The policy of the law is to enforce judgments. As this court said in Emmett, that's referred to in our first skeleton argument. As I've said, it's not challenged that the restrictions are appropriate. The restrictions, in reality, were consented to by Mr. Sue at all material times up until early December. He was subject to a custodial sentence even after that date. There has been gross prejudice to Lakatamia by Mr. Sue's conduct. Sir Michael Burton said that in the first contempt judgment, which the court has, and he said it again last week, and it is obvious. The only other point I need to deal with is the point dismissed by Mr. Justice Waksman in my respectful submission correctly, that Mr. Sue is being obliged by an order of the commercial court to commit a criminal offence. He isn't. Whilst there are no categories to be found in the immigration rules within which he falls, the Secretary of State enjoys a residual discretion under the Immigration Act 1971 to grant an individual, if they apply, permission to remain in the United Kingdom on such terms as she deems appropriate, provided, as the guidance notes say, and I've enclosed those with the skeleton argument, that there are exceptional circumstances. The order of Mr. Justice Waksman requires Mr. Sue to do nothing other than to point out to the Home Secretary that he is required to remain here by an order of the court. And if those are not exceptional circumstances, then it is difficult to see what circumstances would be exceptional. There's one further authority in this regard, which the court, I'll just hand them up if I may, which the court should have, which is not referred to in the skeleton argument. I'm afraid none of us are immigration lawyers, but the Supreme Court has referred to this discretion on the part of the Home Secretary, this residual discretion, and I should just show, for completeness, the court that decision. It's in a case called Munir and Rahman. I won't, if I may, go through the facts, given the time. But at paragraph, I believe, 44, in the judgment of Lord Justice Dyson, Lord Dyson, forgive me.
Yes, so the main point is it's open-ended power outside the rules. That's the point.
The point in the case was that it was a statutory power,
Yeah.
And not a prerogative power. But there's little doubt that it exists. We observed in a footnote in the skeleton of yesterday that when the same submission was addressed to Sir Michael Burton in April, 90 or 100 days after Mr Justice Waksman had made his order, he observed in the course of argument that the point simply didn't arise, because if a court directed someone to be here, then that necessarily made their presence lawful. Might not have worked for President Nixon, but it seems that it does work for the commercial court, at least in the opinion in argument of Sir Michael Burton. So there is nothing in Mr Justice Waksman's order that requires Mr Sue to commit an offence. All that he needs to do, to the extent that he is right that he is committing an offence, is to regularise his immigration status. If he chooses not to do so, or if, having attempted to do so, for some reason, and in my respectful submission it would be unlawfully, the Home Secretary denies the relevant permission, then that is a matter for a court which would constitute a material change in circumstances. But in any event, looking at the proportionality test, or the balance, as the learned judge described it in paragraph 22 of his judgment, that balance, in my respectful submission, is all one way. Because the reality is that this order has either been consented to throughout, or has never had an operative effect in law on Mr Sue, because he has always been subject, or at least was always subject, up until the date that the order was made, to a custodial sentence. The point has not been taken, although it could, there's an answer to it, that he was subject to a restriction for between the period January 2019 and his first committal. That period was, of course, taken into account by Sir Michael Burton in reducing the first sentence which was imposed upon him from 24 months to 21 months. My ladies, my lord, unless I can assist the court further, those are Lakatamia's submissions.
I'm very grateful, thank you. Mr Grant?
My lady has granted me such indulgence today that I feel duty-bound to be very, very short, albeit that is a submission I've made many times to this court without necessarily adhering to it. I will adhere to it today. I'm not going to deal with everything my learned friend has said, obviously. I don't have time to, and I think my lady knows what my case is on most of the points. Can I just address 3 or 4 particular submissions my learned friend made? First of all, he made some submissions about this court's ability to interfere with Mr Justice Waksman's order. And he addressed my lady on 2 authorities which suggested, he would say, that there is a wide latitude accorded to Mr Justice Waksman which requires some fundamental error or something along those lines before this court will act. I don't accept that the authorities which my learned friend directed the court's attention to are of any relevance in this case. This is not Mr Justice Waksman was not exercising, in my respectful submission, a pure discretion, nor was he exercising a pure multifactorial balancing exercise. There are 3 points on this appeal. The criminality point is either right or wrong. Even if it's not right in pure terms, it's right, it comes in on what I describe as what I've referred to as the proportionality balancing exercise. That is an exercise which one has to just undertake. The court did not do it below. This court must therefore intervene. The second head of appeal, or ground of appeal, is my change of circumstance, passage of time point. I don't accept that Mr Justice Waksman addressed the point at all properly. In any event, my submission is that is my transmogrification point. It's not a question of deciding that the means hearing remained a valid objective for Lakatamia in January 2021 or not. It may have done. It may have remained a valid objective for Lakatamia in 2021. That's not the question, though. The question is that a form of order devised by this court 35 years ago has particular characteristics. Those characteristics had long since been departed from by January 2021 for the reasons that I've sought to elaborate. It's not simply a question of making a decision as to, well, does it still have utility? It simply had become a different and unlawful beast through the passage of time, in my respectful submission. And that brings me on to my second point, which is that my learned friend suggested that by consenting on 2 occasions to the adjournment of the means hearing, Mr. Sue necessarily had consented and acquiesced in the adjournment, or rather the continuation, of the passport order, so as to deprive him of the ability even to argue before your lord, before my ladies, my lord, that this order had ran too long and had stopped being within the proper boundaries of a passport order. I emphatically reject that submission. Consenting to the adjournment of a means hearing did not carry with it any acceptance of the legitimacy of the continuation of the passport order. My learned friend answers that by saying, well, they came hand in hand. Well, it may have been decided by Mr Justice Waksman in January 2020 that the one was an ancillary to the other. That does not mean that they march hand in hand, shoulder to shoulder, month by month, as the year elapsed in 2020. And what was the nature of that consent? Well, he consented in March 2020, as we know, in the circumstances which I have identified. Ashford's then write the email in June 2020, which is at page 25. I'm not going to invite the court to open it up now, but I do invite the court to read that email. In page 25 of the clip of correspondence that my learned friend's solicitors insisted we bring to this court's attention, where the email is quoted at page 25 in one of Ashford's emails of either yesterday or the day before, where they in terms asked that the hearing be brought on as a matter of expedition. That's in June 2020. It is right to say that Mr. Sue wrote that email, which we've looked at, in December 2020, an email which I characterise as, with the greatest respect to Mr. Sue, as a very odd email. Now, I'm not suggesting that Mr. Sue technically lacks capacity by reference to the law of capacity devised in this country. But any one reading the material one has been put before the court cannot help but think that even if technically he doesn't lack capacity, here is a man who has been mentally affected by his ordeal. Now, I'm not saying that to elicit any sympathy. I very much suspect sympathy may have dried up in these courts in that regard. But I address the court on that and make that submission to show that the notion that this was a fully functioning, rational being in full charge and command of consequences for doing X or Y is just not a credible position. And indeed, my learned friend told me, and I hadn't heard this before, he told your lordships, my lady rather, just now, that apparently after Mrs. Justice Cockerell had relaxed the reporting limits from 7 days a week to 2, apparently Mr. Sue then wrote to the court, or perhaps wrote to Hill Dickinson, saying that he wanted to go back to 7 again. Now, that's not a rational thing to have said. I wish to go back to Charing Cross Police Station every day. That's patently not a rational thing to have done by Mr. Sue. So his consent was A, not a consent to the continuation of the passport order, B, was a consent in March 2020 and then in December 2020, when just a matter of days thereafter he issued the application that came before Mr Justice Waksman. So one has to weigh that, bear that in mind in my respectful submission. And is the consent of a man who it would appear is not making rational choices about his predicament. Now, my learned friend, and I'm going to be 2 more minutes if the court would permit me. My learned friend said, well, look at the letter we sent on the 20th of September 2020. We were inviting Ashfords to make an application, and they didn't do so. Mr Crichton sits behind me. They had no money. They were trying to come off the record. They were trying to persuade Mr Sue to sign a document allowing them to come off the record. Eventually, they had to make an application to do so. So it's not because Ashfords were sitting there thinking, no, we quite accept that. They were in a difficulty themselves. That's a real-life difficulty. And in any event, let me just make this fundamental point as I characterise it. The answer to the longevity of a passport order is not with the submission, well, we tried our best to bring the matter on, and we also had to make these applications after the first Waksman order, and it was important for us to get this search order up and running. It was important for us to execute that. Now, my submission and my appeal does not depend on this court taking the view that decisions made by Lakatamia, with advice from their lawyers at various stages over the last year or two, were not rational decisions. I'm not suggesting that seeking a search order was some irrational or illegitimate thing to do. But the premise of my learned friend's submission is that as long as we are, as a litigant, actively promoting the underlying order, which the passport order is a handmaiden to, ergo the passport order remains valid. I fundamentally reject that submission, and I invite the court to fundamentally reject that submission, because that, if it's right, it turns a passport order into the limited creature that it has always been, into essentially a creature that can extend potentially for months and years, so long as the underlying litigation purpose of the litigant in the shoes of Lakatamia remains legitimate. And essentially, my learned friend's submission requires there to be a joinder at the hip, if I can use that metaphor, between passport order and the underlying litigation purposes of Lakatamia. And as long as those underlying purposes remain valid ones, the passport order flows in its wake. That is to simply transmogrify a passport order into something completely different from the true ambit of the order. The passport order by January 2021, had ceased to be a passport order as understood and known and modelled and moulded by this court. It's nothing to the point that Lakatamia thought this was a good idea in order to make the means hearing more effective. On that analysis, one could postulate scenarios where the passport order remains in place for years on end, because the underlying means hearing might have some further avenue to be pursued. I've already addressed the court on section 258. As a matter of reality, in every conceivable approach to reality, once you're released from prison after serving half the sentence ceases to exist as anything meaningful. It doesn't have any effect on you whatsoever. So the notion that you're still somehow subject to a custodial sentence on the day you're released, it's just a chimerical submission. Finally, Mr Justice, Sir Michael apparently said, according to a footnote in my learned friend's submission, I don't question that he said it, that if the commercial court says you've got to stay in England, therefore that's a kind of trump card to the criminal law. With the greatest respect to Sir Michael, I'm not sure whether it was a fully reasoned dictum after he'd analysed all the underlying law, but with the greatest respect to Sir Michael, just wrong. And with that very great indulgence, which my lady has given me, and I'm very apologetic for having gone on longer than I said I would, unless I can assist the court any further, those are my submissions.
No, thank you very much indeed, Mr Grant. As you will recall, there were a couple of times during the hearing when we mentioned the production of a chronology, I'm sure you haven't forgotten that. It
No,
would be
it's
extremely
being
helpful.
done, my lady.
Thank you very much indeed. And I hesitate to set you a timetable for that, but sooner rather than later, and if it were possible to have it perhaps by close of business tomorrow, that would be very useful.
I think not later than tomorrow morning it will come, and
Thank you.
Professor Goodcamp and Mr Turner will agree it.
Thank you.
Can I just, I'm so sorry to interrupt. Just early tomorrow might be problematic because myself and Mr Turner are appearing in another tribunal at 10 o'clock tomorrow, and there's quite a lot of work to do.
I was just
Friday
suggesting,
evening
therefore,
might be better.
by close of business
Yes.
tomorrow. If that's convenient for you both, that would be very helpful. Thank you very much.
Can it be emailed to us as a Word document
Of course.
along with
if it goes to my Lady Justice
it can be
Asplin's clerk,
distributed.
I think it will
It
come
will
to all
be
three.
it will be circulated.
Yeah.
I think your ladyship knows, because you gave permission for it, that there's also a transcript.
I did.
Would you like that or not?
I think that would be helpful. Thank you very much indeed. I gave permission, but I did not give permission for breaks for the transcript writers. I'm sorry if that's put them under pressure, but as you can see, we have been under pressure as to time today. So I think it was the right thing to do. Thank you very much indeed to both of you.
Grateful.
Thank you, my lady.